Thank you, Teresa, and the panel. It was very helpful, and I think the takeaway for sure is to keep the dialogue going, particularly here at Plenary, where we have this ability to collaborate and have these conversations and amass the feedback that is so material to shaping what's to come. We'll turn now to our next panel discussion, and I invite the panelists to come up. This is with respect to tribunals and tribunal delay issues. I'd like to welcome up Kathy Laird, a member of Tribunal Watch Ontario, that monitors fairness and accessibility at various adjudicative tribunals. Sam Mason, staff lawyer and clinical instructor at Parkdale Community Legal Services in Toronto, very familiar with various tribunals in the Landlord-Tenant Tribunal. And Marianne Strong, current president of FOLA, very active and involved in civil litigation, insurance, accident benefits, and various tribunal work from there as well. Happy to hear their thoughts and comments on the plight of various tribunals in Ontario.
You have stars.
Okay.
Are
my slides on?
They're on, but if you stand at that podium, you'll be able to see a monitor.
Oh, so I should.
It's Kathy.
I should go to the podium.
I'm just in the LTV. Oh, sorry. That's okay.
Okay. Good morning, everyone. So I'm going to deal with about 4 questions. I'm going to speak about the Human Rights Tribunal primarily. And the questions are, what is the job of the Human Rights Tribunal? How well is it performing in 2025? How did we get here? What are the root causes? And what steps is the tribunal taking to address the backlog and the delays? And what are the impact of those changes on efficiency and fair process? As I'm sure you all know, the Human Rights Tribunal was established as a direct access tribunal for human rights in 2008. The legislation removed the Commission as a gatekeeper to the process and allowed applicants to file their applications directly at the tribunal. Can everyone hear me? I'm not sure if this is all at the right angle.
Move the microphone up. Just move the microphone.
Well, if that's okay, I won't need to, right? Everyone can hear? Yes, okay, perfect. Now it seems a little too loud to me. Okay. Okay. Okay, I hear the echo, but you don't, so that's okay. The then Liberal government established the Human Rights Legal Support Centre to provide free legal services to applicants, including up to representation and summary advice along the way. Under the new system, approximately 80% of applicants are now self-represented when they file their applications. The Human Rights Legal Support Centre has not received a cent of extra money since 2008, not even for inflation, so its services have shrunk considerably, I would say by about half. The Centre is still able to provide summary advice, but it represents a limited number of people at mediations and hearings. But there aren't many hearings these days, so that's how it goes. Under the new legislation, the number of applications filed increased from about 1,500 a year to about 3,000 and eventually went up to 4,500 before the pandemic. Whereas under the old system, only about 10 cases a year went to a final decision. So under the new system, the average was 110 decisions, final discrimination decisions a year, until the Human Rights Tribunal was moved into Tribunals Ontario. Ontario was establishing a body of human rights law that was persuasive across the country and did help with settlements of cases at all stages, and it informed both sides in the community what their rights and obligations were. So it was a win-win, I would say. In the last 5 reported years, the average number of merit decisions has fallen from 110 to 39. Okay, now how do I get the slides to
The
change?
clicker. Yeah, you got it.
This one here? Okay. Okay. I guess that isn't the whole slide. I don't know, is
you press
there
it
a
again.
way? Oh, press it again?
Is that what you want?
No, it's still only half, but maybe it's enough. No, yeah, go back. It's probably my fault for trying to get too much on a page, right? Okay, so there's 2 columns in the slide, and one shows the number of new applications filed annually. And what I wanted to show by the red numbers is that the number filed annually fell quite a bit during the pandemic. Cumulatively, about 2,500 fewer cases over those years. The backlog didn't shrink. The backlog was last reported in 2016-17, a long time ago, and it was under 5,000. And then it wasn't reported for many years, and then the first year it's reported again is the number you can see there, which is 9,000. So it had grown after the tribunal went into Tribunals Ontario, and then even though the volume of new cases was way down in the pandemic years, the tribunal didn't manage to do anything about that. In the last year, it went down by 1,000, and so we're going to talk about how it managed that. Okay, next slide. This slide just tells you about the delays for the merit decisions. So we looked at all the merit decisions for these 2 years. In the last fiscal year, the one that just ended, 85% of cases were filed in 2020 or earlier. So, these are really old cases. I was an adjudicator at the Human Rights Board of Inquiry in the 90s. And in those days, the cases we heard were 4 years old. And I can tell you, it's no picnic trying to make findings of fact when everyone's forgotten. And so for many years, we didn't have this problem, and we now very much have this problem again in Ontario. Okay, so it's not a question of not enough resources. The government actually has poured money into a case management system that doesn't work. Just yesterday, they posted new KPIs, key performance indicators, and for both the LTB, the Landlord and Tenant Board, and the Human Rights Tribunal, they said they were still working on trying to figure out how to do reports under the case management system. This is a system they purchased in 2019. So it's not a question of not resources, and I also wanted to see that there's lots more administrative staff, and the number of adjudicators is more than ever before. It's now at 70 adjudicators, a large number of whom are part-time adjudicators, but there's still a full complement, basically, of full-time adjudicators. So it's not that the government, it's not a question of saying you need to give the tribunal more money. I think it's a question of leadership. Okay, so how did we get here? The first thing is that when the Ford government first took office, they declined to retain the experienced adjudicators at most of the tribunals in Tribunals Ontario. There are 13 tribunals there. So the Human Rights Tribunal lost basically everyone, maybe 2 or 3 remained for a short period of time. For a while, the complement was down by 50%. When they started appointing new people, they just didn't have the expertise, substantive human rights expertise, and they didn't have adjudication background. Many of them had never litigated an admin law case in front of any tribunals, and certainly not in front of the Human Rights Tribunal. And I just know this from looking at the public appointments website, the little bios that they post. They put up their most relevant experience, and there's not a lot of it. The government also got rid of all the experienced leadership. So the executive chair and the associate chairs at almost all of the 13 tribunals. An organization called the Investigative Journalism Foundation looked at this and did a report in 2003 and said that 6 of the 9 senior chairs at Tribunals Ontario have either donated money, served as a high-ranking staff, or run for political office under the banner of the Canadian Conservative Party. Some were candidates at the federal level, some were candidates at the provincial level, which isn't to say they couldn't have skills, but they actually didn't, you know. I don't know. I don't like to make personal remarks, but the executive chair, you know, he's very skilled as a Bay Street pensions lawyer, but he certainly never run a public organization that delivers services, particularly when those services are predominantly, if you look at his tribunals, to marginalized Ontarians to a large degree, right? Because at the Landlord and Tenant Board, you know, 80% of the applications are arrears applications, and people in arrears generally don't have money, and the social assistance benefits, the Social Benefits Tribunal, when I can say from doing human rights cases, if it's an employment case, and most people have lost their jobs. So this is, you know, there are respondents, but often the respondents are small landlords, small employers as well. Okay, so I think I'll move on to the next slide. Oh, I did want to say this, of the 70-odd merit decisions that we're told were released last year, the tribunal hasn't. Their reports are way behind, but the executive chair gave that number at a recent public meeting. So of those 70 adjudicators, 8 wrote 80% of the merit decisions. So there's a small group out of the 70 that is doing the real work of holding hearings and making findings about discrimination. What are the rest of them doing? Okay, did I miss any? Okay, so yeah, this I think it all shows up. The bulk of the new adjudicators are busy dismissing applications without a hearing, often applications that have been stalled in the process for years. They call them procedural and jurisdictional dismissals, and they constitute 93% of all final decisions. There's some comparative numbers there, so it shows that they used to be 41% of final decisions, and they're now 75%, and the number has basically doubled. So this is what the tribunal is doing to reduce its backlog. It's increased up to 4-fold the use of something called a notice of intent to dismiss, and the tribunal itself issues those. Remember, these are all 80% self-represented people that get these notices of intent. So, yeah, imagine you filed in 2019, and in 2024 you hear from the tribunal, nothing has happened. The respondent hasn't even got your application, which is the tribunal's responsibility to serve, and then you get a notice of intent to dismiss. So it's not surprising that 80% of those, 81%, people abandon their applications. The other 20%, they try to file submissions. I guess I haven't said yet what they're being asked for. They're being asked for written submissions on jurisdiction. And they're supposed to address the nexus between the conduct complained of and the ground of discrimination that they've claimed. They may go to the Human Rights Legal Support Center for help, but the center now can't meet the deadlines. The tribunal uses a number of different tools now, not just notices of intent to dismiss, called NOIDs. They use requests for additional submissions. They use case assessment directions. They use a bunch of different tools with different deadlines. Like sometimes they'll send 14 days, sometimes it'll be 7 days. Some of the, like a NOID is under the rules, but the request for additional submissions isn't, and they have different time periods. So it's just a moving target, you know? Okay. So you've seen those numbers, so I won't dwell on that. I did want to say that of the abandonment dismissals in 2024, half were filed more than 3 years before, and about a quarter were filed more than 5 years before. How am I doing for time?
You've got a few minutes.
A few minutes, okay. Okay, so I think I kind of gave you the example already, so I'll move past that. Most of these dismissal decisions have the exact same wording in them. So that's another cause for alarm. And there would be, over 1,000 of those a year. The tribunal relies on 3 decisions in dismissing this way. One is a decision of former Associate Chair David Wright, Ford versus Elementary Teachers Federation. It's a 2011 decision, and in that case, he dismissed, saying you had to be able to show the link between, of course, between the conduct and the ground of discrimination. But it was after a summary hearing in which the applicants had were able to make oral submissions. I think I haven't told you yet that the code requires that no application can be dismissed, with no application within the tribunal's jurisdiction can be dismissed without the opportunity to give oral submissions. So the decision of right that they rely on, they did have the opportunity. And what used to happen is this tribunal, if they thought an application looked weak on its face, they would schedule a summary hearing, usually by telephone, and the applicant and the respondent were on the phone, and the applicant could explain why they thought their case constituted discrimination. And as Wright says in his decision, in many discrimination cases, the evidence comes from the respondent's disclosure or from testimony. I mean, I've heard hearings like that. Respondents actually on the stand tell you why they did it. And so if you're dismissing these based on written submissions from unrepresented parties, it's questionable. So then there's 2 div court cases, Bellow and Hay, and in both of those also relied on. The dismissals happened after there had been oral submissions, and in one case, Hay, it was after a full multi-day hearing. So the cases they're relying on are not really covering the situation that they're being applied to. Okay, let's see. Oh, I guess, so what I've given you here is some examples. Okay, so in Thompson, an application was filed in 2019. The pleadings were complete in 2020. 4 years later, the applicant got a request for additional submissions within 14 days. In the next one, McCarthy, okay, I'm running out of time. So I'll move on, but you have the idea. I want to also say that the test for jurisdiction changed. It used to be that the tribunal applied a plain and obvious test, which is the test the courts apply, but they've now issued a practice direction saying that the test is it's on a balance of probabilities. So the case only goes forward if the adjudicator is satisfied on the basis of the written application and any additional submissions, which are usually not written by lawyers. It's only if they're satisfied that it's more likely than not that the applicant will be able to show the connection. Okay, I do want to give you some examples. I'll just move along. I wanted to tell you that the tribunal is making a lot more errors leading to dismissal. So we looked at the recon decisions, and what you find in the recon decisions is that applicants have filed within the 14 or 7 days, but they didn't get uploaded. And so then they weren't uploaded, so it gets dismissed. And so then the applicant, and there's just a rising number of these, so you put new procedural requirements and then you don't properly upload them, and cases get dismissed. And an unrepresented person is going to get discouraged. Not everyone is going to file a recon application, and there's nothing in the materials they get that tells them they have the right to file a recon application. Okay. I just want to give you some examples of the kind of things that go wrong. Like sometimes it's the tribunal demands something completely unnecessary. An example of that is a Children's Aid Society case in which the applicant and the respondent both wrote, the Children's Aid, to say the Children's Aid case has now settled, the deferral of the human rights case should end and the human rights case should go forward. And instead of doing that, the tribunal wrote to the applicant asking for an update, the update they'd already received, and the applicant didn't respond to that, and then the case got dismissed as abandoned, sometimes the applicant's punished when the respondent fails to file a response. There's lots of cases like this. The respondent hasn't done anything for ages. Like I'll give you Matthews and Cineplex Odeon. We know Cineplex Odeon is out there, right? So he files an application, this Matthews guy, and 5 years later, the tribunal hasn't received a response as required by the legislation. It then writes to the applicant and gives them 14 days to confirm the respondent's address. The applicant doesn't respond, and then it gets dismissed as abandoned. The legislation, the rules actually say that if a respondent doesn't respond, the tribunal can deem the allegations to be accepted, proceed with the application without further notice, deem the respondent to have waived. You know, you're familiar with this language. It's in other I don't know, the civil rules, other places. So there's a number of these cases, and they're often against really well-known respondents. A lot are against restaurants, surprisingly. So I feel like among restaurant owners, the word's gone out, just lie low, you know, okay, so I want to tell you just a couple of other kind of shocking things, to me shocking at least. There's a very strict approach to compliance with procedural requirements. So that's the one I had. Okay, so go back. So applicants have been dismissed as abandoned where the applicant failed to copy the respondent. These are all unrepresented applicants. Failed to copy the respondent on correspondence. The correspondence was an extension request. In another case, the applicant responded to a request for additional submissions in 2 parts, but only copied the respondent on the first part. So instead of giving another chance to give it to the respondent, that was abandoned as. In another case, an applicant unrepresented used a Form 11 instead of a Form 3, and it got dismissed. You know, we just found these cases. They weren't reconned. And these are applicants that were still actively pursuing things. They just did something wrong. In another case, they filed documents that were hard to read. They were blurry. They tried 3 times to get better documents. They couldn't do it, and it got dismissed as abandoned for not filing. You know, could have gone to a hearing. Okay, there's a few of these. Not filing witness statements. A lot of these applications have no witnesses other than the applicant. They're making the applicant now file their own witness statement, even though their statement is in the multi-page application. So applicants have got to their hearing and not been allowed to testify and not been allowed to rely on their application. Okay, I could go on and on, but I think you have the idea. There is one last case I wanted to tell you about. It's called Dixon and RK Furniture. It was filed in March 2018. The merit hearing was finally scheduled in May 2024, so 6 years later. The applicant's unrepresented. She has no witnesses other than herself. She identifies as a Black woman. The ground is race. It's a default merit hearing. The respondent is not participating. The applicant is not allowed to testify because she hasn't filed a witness statement for herself. So she's only allowed to make legal submissions. She's unrepresented. The vice chair does accept an audio recording of an exchange with the respondent in which the respondent calls her a monkey more than once. There was an altercation. The applicant, the decision of the adjudicator is that the applicant has not presented any evidence or oral submissions to link the respondent's use of the word monkey to her race or her color. That's a quote. Based on the foregoing, I find no evidence was presented to support the claim of discrimination based on race. That's the end of the quote. So, you know, they could have let her testify, right? So I guess just want to say that the HRTO is now, the Human Rights Tribunal is now firmly under the leadership of Tribunals Ontario. There are a bunch of unqualified people dismissing applications. There's very little human rights law being made. And in spite of that, the last 2 annual reports, the executive chair has claimed that all of his tribunals are well on the way to being recognized, this is a quote, as the best adjudicative tribunals in North America. So, I mean, I would say to you that the decisions and the numbers paint quite a different picture. Okay, thank you.
Hi, my name is Marianne Strong. I'm from OTLA. So for background, the Ontario Trial Lawyers Association, our members are personal injury lawyers that represent the injured claimants or plaintiffs. When we get in a car accident, your insurance company is responsible to provide you with certain medical benefits. When you have a dispute with them, you go to something called the LAT, the License Appeal Tribunal. I'm going to talk to you about the License Appeal Tribunal, the place where you would go fight your insurance company to get your medical benefits. I thought the LAT was in bad shape, but it sounds like many tribunals are in bad shape. So I'm going to talk about some trends with respect to the LAT. The first thing I want you to know is that we went to a company called InHealth to ask them to put together some statistics for us. These are not our stats. We purchased these stats. We did not put them together. So this is not an OTLA document. It's somebody else's document, but we purchased it and asked them to put it together. Before we talk about the InHealth report, you have to know the parameters. The LAT, and the only section of the LAT, the License Appeal Tribunal, does more than just auto. The section I care about is auto, and that's what my talk will focus on. It came in 2016. We were previously, if we had a dispute with our insurance company, we go to something called FISCO. So then 2016, we get the License Appeal Tribunal. When we asked InHealth to look at the stats, we said, look from 2016 up until the end of the year, at that time, was December 31, 2023. So these stats end as of 2023. We do not yet have 2024 stats. We only looked at substantive decisions. So we did not care, for the purpose of this study, about procedural questions. So how many adjournments were granted or not granted. This is substantive decisions. This also, most importantly, and I stress this even with our own members, the data does not tell us why. It does not tell us why every case was decided the way it was decided, but it's a disturbing trend, and in our point of view, it should raise many red flags, and that's what we've been trying to get the word out about. This data also doesn't tell us anything about the many cases that are settled between counsel prior to it going all the way through the LAT process. So possible reasons why we're going to see a disturbing trend, in my point of view. It could be many things, and we are asking that the powers that be explore all of those things. You know, everything from who's doing the lawyering and should there be better training there, all the way to who are the adjudicators, and we heard about appointment adjudicators a little bit. So the appointment adjudicators, the training of adjudicators, and then we have a lot of focus on procedural problems, and I'm going to illustrate that as well. So the procedural problems we see has to do with what evidence is allowed in and how do you conduct these tribunal hearings. Is it done procedurally fair? And are you complying with the rules of natural justice? Divisional Court has many comments on that. So here is the concerning trend. So if you have a dispute with your insurance company and you are an applicant, you're the insured person, you are an applicant, the full success rate as of 2023 is 10%. 71% of the time, the insurance company is winning on their argument. 10% of the time, the applicant is winning at the tribunal hearings. I want to tell you what splits are. Splits mean that I had 2 issues in front of the adjudicator, substantive issues, and I won one, but I didn't win the other. So there are some splits. So maybe they get something, like one treatment plan, but not the other 4 that you were talking about. The splits do not include costs or special awards, which are very rare. So we said take that out of the equation, or else you would have too many splits. It would not be inaccurate data. So we said just on the substantive issue, what's the split? So there are some splits, but overall, full success for applicants, 10% of the time, far majority, 71%, most recently, is the insurance company. We asked them to pull the adjudicator stats and to see if we could see a trend with respect to adjudicators. And to just see a trend based on the different types of disputes. So first of all, 26 adjudicators have over 50 hearings. Some of these have a huge number of hearings and decisions, and some of them have very little. So their experience level is sort of laid out for us. I'm going to go quickly because I know that we have time limits. So if anybody wants the full in-health report, we are happy to share it. Catastrophic impairment. This opens up $1 million under your policy, hugely important to people who are injured. So catastrophic decision trends by volume, we've got 14% success rate for insured applicants and 86% of the time for the insurer. Adjudicators don't have a ton of experience with these types of cases based on what we're seeing, because some of them have one decision, and some of the adjudicators do more CAT decisions. So we're interested to see what the next trends are for the coming years. But currently 14% success rate for applicants in this category. We're going to talk about income replacement benefits. You have a certain amount allowed to you under your policy for income replacement benefits. If they don't pay it, you go to the lat and fight it. 20% of the time, on average, the applicants are successful. 79% of the time, insurers. And you can see there's a few splits there as well, and I didn't pull those overall data for you, but it's in the complete report. If I was looking at medical rehabilitation, we've got 25% success rate for the applicants, 74% for the insurer. Again, far majority for the insurer. This is like, I need a physiotherapy treatment plan. That's the kind of dispute that's going on here. And by far, wrong slide. There's your med rehab slide. There's 18% and 51% for the insurer. So this is the med rehab treatment plan dispute. The last, I think this is almost my last slide on the LAT. So I know I flew through the in-health data for you because I'm aware of time. But if you want that full report, you want to sort of dig deeper into the applicant success rate versus the insurance company's success rate at the LAT, we're happy to share that. The other stats that we care about is the time frame. And for a lawyer giving advice, the stat that we care about is the advice we have to give our client. If you have to fight to get your physiotherapy treatment plan or any other dispute, how long will it take you from the date of your application until you receive a decision? This number is problematic for us. And to be clear, we get this number from Tribunals Ontario. This is their number and their statistic, but we asked a very specific question, the question we care about. How long will it take me as an injured person from day one till the day I get the decision? On average, it's 803 days. What that means is, under your policy, you have 5 years of medical benefits unless you are catastrophically impaired. You will spend more than 2 years fighting about your treatment plan if you have to wait for a complete decision and there's no resolution beforehand. Tribunals Ontario will say there is a 12-month life cycle on average for our files. And that may be true, but I don't know what a life cycle is. I'm going to assume it's from, on average, when you open a file and when you close it. My stat has to do with the auto section. Their stat is the entire LAT. not just the auto section. Their stat likely includes settlement. So insurers resolve the issue, we withdraw it, and numerous of those applications are probably dealt that way. So their average is going to be skewed by that. What we really care about is that 2+ years fighting for treatment when you've only got 5 years unless you're catastrophically impaired. So has there been an improvement in that 803? It's an improvement over, say, 2023 to 2024, but it's not an improvement overall. There's a trend there, and the trend is longer wait time for that. There are about 4,000 applications per quarter that are sent to the LAT and filed with the LAT. And as I said, this delay when you're fighting for the benefits, or even if you're fighting to get into that 5-year category, you spend 2+ years trying to get into there. Divisional court decisions, I just want to take couple minutes to fly through some really important decisional court decisions that highlight problems at the LAT. So procedural fairness, how we deal with experts. If you practice in this area, read these. If you're interested in tribunals and what they do and maybe what they're not doing right, read these. Some of these are disturbing. Buchanan FM and this decision and the next one both deal with expert evidence, and we're starting to see more decisions come out of the divisional court talking about, is the tribunal dealing properly with expert evidence? Do they understand the importance of cross-examination and expert evidence? And here the divisional court comments on the fact that the LAT refused to allow cross-examination, or there was not cross-examination of an expert, the psychiatry, i.e. that report was submitted and it was allowed on an important issue without being tested, and they said that doesn't meet procedural fairness. Lo and behold, not too long after, there's yet another decision sending the same message. Dr. West showed up for examination in chief and refused to show up for cross-examinations. His evidence was not tested. There was a key issue of medication use on causation. I know people are laughing, like, how do you not show up for cross-examination? And then how does a tribunal rely on that evidence after it's not been tested and the doctor refused to come and didn't show up for cross-examination? They relied on it, and the divisional court, not surprisingly, says, you can't do that. That's procedurally unfair. But they keep commenting on experts, and most recently, if you have not read the Plant decision, it's concerning. You should read it. What happened, there's numerous issues within this, but what happened here is that the applicant ended up asking for a reconsideration. The reconsideration's decision is done by the same adjudicator, so not a fresh look, same adjudicator. So, and that document was not accurate as to what actually happened at the hearing. It was written in a very peculiar way, I'm going to say. And the lawyer argued that it was revisionist history and patently false what was written in the document, and the divisional court says 2 words: we agree. If you haven't read it, read it, but it goes on to talk about procedural fairness issues, the importance of natural justice, and they go on to say the adjudicator showed a fundamental misunderstanding of the role of an expert, and then goes on with a long list of other things that they did not understand. Again, the training, who's being appointed, things that we should all be thinking about. The divisional court is hinting at these things if we're listening. Stats, we talk about stats, and here's a recent case. We've had a problem with adjournments at the LAT. The problem with the adjournments is they're routinely denied, and the parties' issues are not being considered when the denials are happening. The Riddell case is actually brought forward by the insurance company. And they fought this, not the applicant side, because they were upset about the lack of the adjournment. This decision is great because it really shows that, and they comment on this, there was more of an institutional concern, frankly, about the timeout stats than there was about the parties and what they needed. And so I think it's a highly important decision about how they function and how important their stats are to them. And this decision highlights that that can get in the way of what's important to actual parties to get to a just result, and the adjournment should have been granted. OTLA's been trying to do the work that we do in advocacy. We've been trying to push for change, and we'll continue to do that. And we've highlighted a few things that we want to be addressed, including who's being appointed, what training is happening, and what procedure is really being used at the License Appeal Tribunal. We need to start going back to fundamentals and making sure that natural justice and our proper rules of evidence are actually being applied. So that's my talk, and I'm sorry if I went way too fast, but there you go.
Okay, good afternoon. Last session before lunch. Tough spot to be in, but I will be speedy too. My name's Samuel Mason. I'm a tenant lawyer, and I'm here to talk about another tribunal. This is the Landlord and Tenant Board, part of Tribunals Ontario, of course, and this is the place where disputes between landlords and tenants are adjudicated. Much of what you heard from Kathy and Marianne, there's similar themes at the LTB. I just put up some relevant statutory provisions under the Residential Tenancies Act. The first is that, again, the LTB is exclusive jurisdiction. And for the point of this presentation is about the delays at the LTB and how the LTB is reacting to those delays. And the LTB is required to adopt, per the legislation, the most expeditious method of determining the questions, but also affording all persons directly affected adequate opportunity to know the issues and to be heard on the matter. So that's the tension. The board's got to move expeditiously, but everyone's got to have a chance to know and be heard on the matter. And what we've found is in the past 5 years, the board has been kind of leaning a bit too heavily in let's get expeditious and not having enough regard for allowing everyone to be heard on the matter, which has led to a series of really consistent decisions at divisional court finding that procedural justice was not afforded. In all the cases I'm going to present, it's on behalf of the tenants. I'm a tenant lawyer. But the findings would apply to all parties at the LTB. But before I move on to the first case at divisional court, I want to first speak about the delays at the LTB. Kathy spoke about how it's the HRTO, the Human Rights Tribunal, and the LTB that are the two tribunals with backlog currently. The LTB is the busiest tribunal in the province. And in terms of delays, this is according to Tribunals Ontario's own stats. So starting at 2016, landlords' applications were resolved a little over a month after the applications were filed. Tenant applications were resolved around 2 months after the application is filed. In 2021, again, it's shortly after the pandemic, but the stats haven't greatly changed since then. Landlord applications take 3 to 4 to 5 months to be resolved. Tenant applications, it's a year. So a tenant who has a leak in their unit, a broken window, a cockroach infestation, the application is they have to endure those conditions for a year. Same with landlord applications, and again, for corporate landlords, they can withstand a lot, but smaller landlords, of course, 3-4 months before an application is heard can be really challenging. So all that to say, these stats are widely reported. The delays at the LTB are reported often in Toronto, but also in smaller jurisdictions. And so there's been a lot of pressure on board members to get through their dockets. And as someone who appears at the LTB regularly, you hear it in their language. They'll say things like, "Oh, I'm not into adjournments," as if it's like something someone is interested or not. Or "I always get through my docket," as if it's like a medal to be worn, when realistically sometimes you have a complex docket that you wouldn't have expected, which you wouldn't reasonably need to get through in one day. In any event, so the first case I'm going to talk about is Shapiro and Swingler. This is one not so dissimilar to the topic of evidence that that we just heard about, where landlord brought the tenant to the board for persistent late payment of rent. The landlord brought no evidence of persistent late payment of rent. The tenant says, I have evidence that I have not been paying my rent late. The board member said, you didn't disclose your evidence, the application's granted. The board can certainly take time, adjourn the matter, allow the parties to disclose their evidence, allow post-hearing submissions on evidence, but that slows things down. Divisional court, of course, granted the appeal, saying procedural fairness was not afforded. Another case, Magnaka and Zoppo. This is one where the tenant missed their hearing at the LTB. They filed a request to review. Much like a recon decision at the HRTO, the LTB dismissed it, saying you didn't attend, you're not getting a new hearing. The board had no record of ever serving the tenant with a notice of hearing, and the tenant was unrepresented. So they said they never got a notice of hearing. So an unrepresented litigant, a tenant, and most tenants at the LTB are unrepresented, misses a hearing, gets an order in the mail, applies for reconsideration or review, saying, I never got a notice. The board's records show no one sent one, and the board doesn't allow a new hearing. Well, the divisional court obviously didn't like that very much. Another one, this is like a double whammy. A tenant's getting evicted on two bases. On their first hearing, they missed it because they had an automobile issue on the way to the hearing. The board said, doesn't matter, you're evicted. On the second case, the tenant was represented by this time, and the board did not send the notice of hearing to their representative. The tenants on social assistance testified to being considerably disabled, and the board said, you're not going to get a chance to have that matter reheard either. They appealed both decisions. The divisional court again said procedural fairness was not afforded. The divisional court has said that in cases where someone's housing is at risk, the degree of procedural fairness is at the high end of the spectrum. And then another case, this is Wright and Lalian. Again, these are all in the past 3 years. This was a case, again, unrepresented litigant. The landlord filed 2 different applications for eviction, but it wasn't clear to the tenant that there were 2 legal proceedings. This young family got 1 notice of hearing for early part in the summer, and then subsequently another notice of hearing, and they assumed it was an adjournment of the hearing date or a rescheduling of the hearing date. So they missed their hearing, appealed on that basis, and again, the divisional court sent it back to the board saying you're not affording parties an opportunity to be heard, especially when they have reasonable explanations for why they missed their hearings. Okay, and the last divisional court case I want to talk about is Ali and Caprit. This was one where tenant, a single mother, spoke to the lawyer for the landlord before the hearing. The lawyer for the landlord asked her to pay the landlord's costs. She did so, and then assumed that the matter was resolved. And then when the hearing proceeded, the lawyer for the landlord didn't say anything to the board member about that discussion. She was evicted, or an eviction order was issued, and she appealed on that basis. In all of these cases, the tenants tried to have the case reviewed first at the LTB, saying I was not reasonably able to participate. And they all have their own reasons, and it's all context specific. And in each of these cases, the LTB has not granted a new hearing on the matter, and the tenants have had to go to divisional court. So in the past 5 years, there's been repeated decisions by the divisional court sending matters back to the LTB, recognizing it's a high-volume tribunal, recognizing they can control their own processes. But the spirit of what's coming out of the divisional court now is hold your horses. Should you go too fast, you are creating a system of procedural unfairness for the litigants. So that's my presentation on the LTB. I thought I'd go nice and quick. If any of you have any questions, I'm sure well, it's up to Alan, I guess.
Yeah, we are running a little over time, I do apologize, but if there are any questions for any of those who have presented, I'm sure we could go on, but you get the general idea that procedural fairness is not the highest priority at some of the largest tribunals we have in Ontario. So this is a serious issue with access to justice. I mean, we're used to a higher standard in the courts, whether we're in the OCJ, the SCJ. We wouldn't expect this type of thing, but a lot of decisions are being made in Ontario through these 3 tribunals, and we thought it important to bring to your attention the lack of natural justice involved. Mark?
Sorry, just a quick question. Do you find that this is a matter of triage post-COVID problem, or is this really indicative of more of a problem with the adjudicators, the training, the badge of just whipping through dockets? What are the trends trying to establish here? Where do you think these issues are really starting to rise?
Well, I think the government has moved to a more summary form of justice where procedural fairness is not, that message is going from the government to these tribunal heads. You hear the Premier talking about we want like-minded judges. Well, they want adjudicators that will plow through the backlog. And, the divisional court is having trouble keeping up in some cases. There haven't been very many good cases reviewing the changes at the Human Rights Tribunal in terms of the change to a balance of probabilities test on jurisdiction, for example. It's really heartening to hear the cases that my 2 colleagues have cited. One thing I would like to ask you is, there's no longer in-person hearings, and the Tribunals Ontario closed down 44 regional offices that were used by the LTD, but also the HRTO did regional hearings. So I don't know if you have any experience with that, but landlords used to get a lot of help at the front desks, for sure. People would have hearings in their own communities, whereas now there are province-wide, at the LTB, there are province-wide hearing blocks. The adjudicators don't travel to the communities, obviously, so they're no longer familiar with the landlords and the tenants and the municipal housing inspectors and the rent bank. And one of the things that the data has coughed up is that and this is the LTB, when landlords and tenants were in the hearing room together in person, between 30% and 40% of cases settled on the hearing date. So that's what the old annual reports tell us. And now that everything's online, of course, mediation doesn't work that well. And they're settling about 5,000 fewer cases every year. So that's how the backlog at the LTB is partly, that's responsible for at least half of the 50,000 case backlog. So, it seems like a lesser quality of justice to me, and I just wondered if there were any experiences about that from the field.
Hi, Angus Bickerton from Brockville, just south of Ottawa. First, I want to ask really a rhetorical question, perhaps for anybody in the room, which is there a system of law in Ontario that actually works? And I'll move right on from that. But my background is primarily in family law and in solicitor's work. But as a solicitor, the LTB issues are one that we come across on a regular basis when you need vacant possession on a sale. It's been a huge, huge deal. And the indications of a lack of training have been alive and well before COVID, certainly at the LTB. I'm not as familiar with the other tribunals, but where rules of evidence, for instance, are completely ignored. And the tribunal won't explain why it decides when $50,000 in damages has been proven on a balance of probabilities and is uncontradicted. They make an award. Their jurisdiction limit, of course, is $25,000. You've proven 50, you've asked for 25, and they give you 8. Yeah. But they don't give you a reason why. And often, the tribunals that I've attended at, and I don't go anymore because, well, it's the LTB, And the person hearing it is often not a lawyer, doesn't understand rules of evidence. And if you talk to a landlord or landlords groups or lawyers who've acted for landlords, there's a very strong bias on their part saying that, well, the tribunal only decides for tenants. I know that's not true, because I've just been reading that case law on the screen. I've heard what you've had to say. The LTB seems pretty good at messing it up both directions.
Yeah.
And so my question is, with such an institutional failure, what do we do? Like, I'm kind of sitting here in a rather hopeless period in our history with all the stuff that's coming out of the United States and Ukraine, and now we're talking about just about every system of justice we've had this morning has been broken. What do we do?
It's been surprising to me that the government doesn't care about the small landlords, frankly, because that's been in the media a lot. And, you know, I'm not surprised that they're not necessarily listening to tenants, but that is part of their constituency. I'm surprised that there isn't more concern on the automobile cases. They must hear that from their constituents. So it is surprising. But, you know, well, the last election, it wasn't fought on issues of what's happening to the universities, what's happening to your justice system, what's happening to the healthcare system. So we're not, yeah, I don't know what to say. It's pretty discouraging.
Yeah, I would say if more people educated their MPPs, that might be helpful. So reach out to your MPPs about what's really going on. You'd be shocked. I talk about auto all the time. Nobody understands auto. Nobody, cares about it until you're in a car accident. So until they really understand what's going on, there won't be change. And to Mark's point, we could all choose to believe that they're willfully ignoring rules of evidence and willfully ignoring rules of natural justice. Or we could say, gee, they must be poorly trained and unqualified. So I don't know what the right answer is there, but if it's a poorly trained and unqualified, then we have to push for better selection process, and better training of adjudicators all around, and look at what laws are being implemented and how are they being used at the tribunal level, and push for changes for that.
Sorry, you know what, I do apologize. Okay, go ahead,
Just
quickly.
very brief. It was on your point about the in-person hearings. After COVID ended, my own local judges issued a practice direction that all case conferences and settlement conference had to be in person unless you got advance permission. And the reason is because we all noticed it, when you don't have somebody in the room physically, they're not as inclined to listen. They're not as inclined to engage in a process. And I can't count over the times of my career how many times I settled something, quote unquote, on the courthouse steps.
Yeah.
In the hallway, in a council room.
Absolutely.
And if you don't have that gravitas of sitting in front of a dais with a judge sitting there or a decision maker with other people waiting their turn and so on, and how important it is, it's just a video.
Yeah, I mean, I think that says it all, really.
It doesn't work.
Yeah. Good comment. Listen, we are running behind, and I do apologize. This was an important topic, so I'm happy we were able to bring this to you today.